Welcome to part 2 of Cat Photographs and Celebrities. Let's turn to the other overlord of content on the internet, celebrities. Before I go any further, a disclaimer. Some bar associations consider this to be attorney advertising. Prior results do not guarantee a similar outcome. This presentation is for educational purposes only, as well as to give you general information and a general understanding of the law, not to provide specific legal advice. There is no attorney-client relationship between you and the law office of Tanya Pohl, LLC. This presentation should not be used as a substitute for competent legal advice from a licensed professional attorney in your state. In the first part of this presentation, we talked about needing permission from identifiable people in photographs. That's because people have a right to control the commercial use of their image. Depending upon the jurisdiction, this is called the right of publicity or the right of privacy. Celebrities also have this right. Celebrities have the right to control the commercial use of their name, likeness, and image. In addition, celebrities can also take advantage of a provision in the Federal Lanham Act prohibiting false endorsement. To succeed on such a claim, the celebrity must prove that a use in commerce created a likelihood of confusion as to the celebrity's association or sponsorship of products or services. Your business may be tempted when you see a photograph or read an article about a celebrity using your product or service. Be extremely careful how you refer to celebrities on your business's social media account. Celebrities have the right to walk around in public wearing clothes designed by a particular brand, or shop in a particular business, or eat at a particular restaurant, without endorsing a product. To put this in perspective, remember that celebrities can receive a lot of money for promoting products on social media. If a business uses their name, likeness, or image for free, that's a threat to the celebrity's potential source of brand sponsorship. They may well sue to protect it. You may be wondering, but what about the First Amendment and freedom of speech? Freedom of speech has some limitations. In general, intellectual property rights, like copyright and trademark, are a limit on freedom of speech. Second, some kinds of speech receive less protection under the First Amendment. Commercial speech receives less protection under the First Amendment than other kinds of speech. Political speech receives the highest protection, followed by expressive speech, which is entertainment. That's one of the reasons that you shouldn't post the same kinds of messages on a business account as you would from a personal account. As non-commercial speech, a personal account has more protection. That usually leads to another question. But this particular post isn't commercial speech, it's just brand awareness, right? Well, courts and marketing professionals have very different views on what commercial speech or ads are. For example, many of us wouldn't consider a post commenting on a celebrity death to be an advertisement. Many of us do not consider many kinds of social media posts to be advertisements because the posts do not promote and sometimes do not even mention a specific product or service. Rather, we might consider those posts to be raising brand awareness. Unfortunately, courts tend to consider all of this to be commercial speech. As a result, it is safer to always assume that any post that comes from a brand or business account is commercial speech. There are two related lawsuits, both involving Michael Jordan and Chicago area grocery stores, that strongly suggest that courts will consider most speech from a business's social media accounts to be commercial speech. In the two separate grocery store cases, Michael Jordan sued the stores for alleged violations of his right of publicity and for false endorsement. In the first lawsuit, after Jordan was inducted into the Basketball Hall of Fame, a Chicago area grocery store called Dominique's allegedly took out a full page in Sports Illustrated. This full page allegedly said, "Congratulations, Michael Jordan," featured a reproduction of Jordan's Chicago Bulls jersey in the Chicago Bulls colors of red and black, and a basketball. The bottom portion allegedly had a coupon for $2 off of steak at the grocery store. In the second lawsuit, another Chicago area grocery store, Joel Osco, allegedly took out a full page in Sports Illustrated magazine congratulating Michael Jordan on his accomplishment. The print page allegedly had Michael Jordan's jersey number 23 for the Chicago Bulls on a pair of sneakers. It allegedly called Michael Jordan a shoo-in and congratulated another Chicagoan who was, quote, "just around the corner." This page did not include any reference to a product or mention what Joel Osco was. It allegedly contained Joel Osco's name and trademarked slogan, "Good things are just around the corner." The phrase "just around the corner" in the Sports Illustrated tribute to Jordan was allegedly a reference to Joel Osco's slogan. Turning back to the first lawsuit involving Dominique's, it's easier to view that the $2 off coupon for steak might be an advertisement. The grocery store allegedly was advertising a specific product it sold. That seems more like commercial speech. But what about the other grocery store, Joel Osco's alleged tribute in Sports Illustrated, which did not reference a product or even state what Joel Osco did? The appeals court held that this was an advertisement in Sports Illustrated and it was commercial speech, even though it did not reference a product or service. What was the appeals court's reasoning? Well, the tribute allegedly included the grocery store's marketing slogan. It allegedly included the grocery store's name. The court called this image advertising that enhanced consumer goodwill. That's commercial speech. The lawsuit against Dominique's resulted in an $8.9 million jury verdict. Jordan settled the second lawsuit against Joel Osco for an undisclosed amount after the appeals court ruled in Jordan's favor on the commercial speech issue. These cases may have involved traditional print media, but the consensus among legal professionals who deal with social media is that these cases have a lot of implications for social media. Courts are likely to consider most social media posts from a business or brand account to be commercial speech, even if they do not reference a product or service. To be cautious, assume all business social media posts are commercial speech. Let's look at another example of a celebrity false endorsement lawsuit. In 2014, Duane Reade Pharmacy allegedly posted on Twitter and Facebook a photograph of the actress Katherine Heigl holding a Duane Reade shopping bag. They allegedly included a caption stating, "Love a quick #Duane Reade run? Even at Katie Heigl can't resist shopping #NYC's favorite drugstore." The actress sued for false endorsement under the Federal Lanham Act, as well as violation of her publicity rights. The complaint alleged that Duane Reade downloaded the photograph from a celebrity gossip website and placed the photograph on its social media accounts with the caption tagging Ms. Heigl and using Duane Reade's marketing slogan. Let's discuss some potential problems if these allegations were true. There were a couple of things that Duane Reade allegedly did that would be best for any business to avoid. First, do not link or tag the celebrity. If Duane Reade had done this, it would have allowed them to allegedly capitalize on Katherine Heigl's social media followers without her permission. Access to her followers is valuable. Second, the commentary Duane Reade allegedly added arguably made it sound like Katherine Heigl endorsed Duane Reade, rather than merely shopped there. The alleged use of Duane Reade's marketing slogan in this post increased the likelihood that a court would have sided with Heigl. Finally, Duane Reade allegedly copied the photograph off of a gossip website and uploaded the photograph to their social media account. They allegedly didn't license the photograph or ask for permission. That's copyright infringement, and the owner of the photograph could have filed a separate lawsuit against Duane Reade for copyright infringement. Here are some takeaways. Think long and hard about whether you want to refer to the celebrity by name or use his or her image. Another way of saying this is that you have to consider your business's risk tolerance. Celebrities are becoming increasingly litigious about protecting their brand because it's a source of income to them. Never upload an unlicensed photograph. That's copyright infringement. The owner of the photograph can sue. If you determine that it's worth the business risk to tweet or post the image of a celebrity using your product or service, then it is generally safer to link to the photograph. Linking is generally safer. Always avoid tagging. That's using the celebrity's social media handle or account or @ing the celebrity. Always avoid adding editorial content that includes your business's marketing slogan or makes it sound like the celebrity endorses your business. Thank you for listening to both presentations on cat photographs and celebrities. Marco Tan took all photographs of our two cats, Pierre and Jack. I hope you have found these presentations to be fun, useful, and informative. Thank you once again.